Hi, and welcome to this edition of the People's Law School. My name is Keith Taylor, and I'm a practicing attorney in the state of Florida. In today's edition, we're going to talk about some basic estate planning principles. One of the things when we're looking at estate planning is considering the different events that could affect a person's lifestyle, and particularly at the time of their death. Most people are familiar with wills and what happens when a person dies. Today, however, we want to talk about what about a situation where a person becomes incapacitated prior to their death. In doing that, I'd like to use a little timeline. If we're looking at the course of time, and we are here today, everything is working fine for us. We have no need to have anything in place. But because we know one thing certain in life, in addition to taxes, is death. One of the things in the course of estate planning that we look at is planning for death. That is done by what most people refer to as a will or last will and testament. But what could happen is prior to death, a person could experience a period of incompetency. That is where they are no longer legally capable of making their own decisions. They can't speak for themselves, and they are then normally under what's called a guardianship proceeding, which is a legal proceeding that can be very expensive, time-consuming, and unpredictable. So the key is that a person act while competent to take steps to deal with a period of incompetency. So as I like to say, it's important that we act now. In doing so, one of the things that we look at is the concept of a living will. A living will is a document that you would execute while competent that expresses your wishes if you ever became incompetent and met certain criteria. Most people are familiar with the case that involved a nice young lady down in South Florida by the name of Terry Schiavo. Her case centered around the issues that involve a living will. We really wouldn't know a lot about Terry Schiavo if it was not for the fact that she did not have a living will. It was the dispute that arose between her husband, who maintained that she did not want to be artificially kept alive in her state, and her parents, who took the opposite position. As you may recall, that litigation lasted many, many years and cost both sides hundreds of thousands, if not millions of dollars. So for a person who has watched that experience or has ever said, you know, if I'm ever like Terry Schiavo was, I do not want to be artificially kept alive, then a living will is a document that you would want to execute while competent. In a living will, we address a couple of things. One is, what do you want? In fact, let me back up. A living will is referred to as an advance directive. You're directing what you want to happen in advance of a situation. And a living will typically would arise in Florida under two situations. One involves being in a persistent vegetative state. That was the situation of Terry Schiavo. The other situation would be if you're at the end stage of a terminal condition and you are not competent to speak to your desires. In other words, you're going to die from the condition, and you are just simply being kept alive artificially by machines, breathing tubes, and those type of medical apparatus. So while competent, you're able, by written document provided by law, to tell the doctors and your loved ones what you want if you ever are placed in that situation. One of the things we try to address is pain. Do you want to be maintained pain-free? Most people do, and so we express in these documents, listen, I don't want to be kept alive just to be kept alive, but I don't want to have pain. And that's one of the things that a lot of people have concern about is, I don't want to suffer, but if I have no quality of life, I don't want to be just kept alive. Another thing that we oftentimes address in an advance directive such as a living will is artificial feeding and hydrating, or providing water or food to you if you're unable to feed yourself. What you want to do is, in your living will, direct your particular desires with regard to that. The last part of the living will that we especially like, and I think it really grew out of the Terry Schiavo situation, is where you designate somebody to speak for you. You know, in this day with the privacy laws, the hospitals and the doctors don't give anybody any information related to your health care. And if the issue involves should you be on life support or should you not be on life support, and answering these difficult medical questions, in your living will you'll want to designate somebody who is authorized to get that information from the doctors and authorized to stand up for you, speak for you, so that what you want with regard to your end-of-life decisions is carried out. For any other questions on living wills, you can visit our website, www.keithtaylorlaw.com. Thank you. My name is Keith Taylor. You have a great day.